So first of all, I think it's important to understand what the meaning of the word probate is. And the very meaning of the word probate is that your will is being filed with the court by your executor or personal representative for it to be proven to be your last will and testament. So probate is proving the will, that it's the most current will that you have when you've passed away. And it's about the orderly administration of your estate after you've passed away. There are probates where there is no will, so intestate probates, and then testate probates where you have a will. But it's basically going to court and asking the court to enter an order formally appointing your executor, personal representative, to act over your estate, to have the authority to make decisions affecting your estate. The probate process can typically take several months, could be shorter, could be much longer. It really depends on the circumstances of the case. Number one, are there any complicated assets like dividends that are being paid out or real estate that needs to be listed and sold? Maybe things need to be cleaned up, improvements need to be made, maintenance, and so forth. Those sorts of issues can make it take a little bit longer. Family dynamics can also complicate things, especially if you have an intestate probate. If you have a will that's clearly outlined, who are your beneficiaries and how much do they get and all of that, and who's in charge, who's your executor, then the executor has some authority once formally appointed by the court. And that can depend too if the executor, or what we call personal representative, has non-intervention powers or needs to go to court for approval for every decision. So there are a lot of different factors that weigh in terms of how long the probate process can take. With probate, the costs associated are usually attorney's fees, to have an attorney lined up to advise the executor, personal representative, to prepare the pleadings that need to be filed with the court, and the pleadings and court orders that need to be entered to make temporary and then final decisions with regard to the administration of the estate, distribution of the estate. You're also looking at court costs like the filing fee. You may also look at appraisal costs if you need to have appraisals done for valuation of assets, if you have any estate tax concerns. There might be like closing costs, realtor fees, things like that. There might also be accountant or CPA fees to file like a final income tax return or like a trust return if there's a trust, and perhaps an estate tax return if there's a taxable estate. So some or most all of the fees people can expect in a probate matter. So a lot of people come to us because they want to avoid probate, and with good reason, especially in states like California and New York. In Washington state, we have a simplified probate administration state. However, if you have any real estate, especially real estate in another state, in addition to your real estate in Washington, you want to consider ways that you can avoid not only probate in Washington state, but what they call ancillary probate in the other state where you have real property. Because if you die and you have real estate that's titled in your name or you're in your spouse's name, that can prompt the need to open probate to appoint an executor or personal representative who then has authority to list the property to be sold or transfer the property to your beneficiaries. Whereas if you create a revocable living trust and you put the real estate in the trust, that can avoid probate. Other ways to avoid probate are having TOD or transfer on death or payable on death designations, beneficiary designations, like in your life insurance, naming an individual to receive your life insurance or receive your bank account or your investment account. So those are some other ways to avoid probate. And why should you avoid probate? Well, a lot of people think of it as invest now in a proper estate plan or pay later with probate. And I would say that the attorney's fees and costs associated with probate are going to be significantly higher than if you just create a proper estate plan in the first place. The other reason to avoid probate, a lot of people want privacy. And so a trust can be more private, where it's between, their professionals that are working for them, their attorney, CPA, financial advisor, and their family members or whoever they might have. A lot of people don't want to name family members, whoever they've named to act with authority over their estate, their trust estate, and then whoever they want to benefit. So it's kept private. If you have any questions about probate, contact us through our website, clearwaterpnw.com. Thank you.